that one. It looks like a Wi-Fi sign. I just said good morning, everybody. The arrangement was that we will start the proceedings at 10 o'clock, but because of some technical issues, technical problems, there has been a delay, and I understand that an apology was offered, and I'd like to offer the apology as well. I'm not happy that we start almost half an hour later, but unfortunately we couldn't do otherwise. I don't know if it's okay. You don't see Google Lines. Is he here? Oh, there he is. Advocate Libber, ladies and gentlemen, and I think amongst us is the chair of the board of the PIC, Deputy Minister Gungubela. You may sit down, Mr. Libber. This is a sitting of the Commission of Inquiry into allegations of impropriety regarding the Public Investment Corporation, an asset management company that manages assets for clients, one of which is the Government Employees Pension Fund. The Commission was established by proclamation signed by the President of the Republic on the 4th of October 2018, but published in the Government Gazette number 41979, dated 17 October 2018. I am Lex Mpic, former President of the Supreme Court of Appeal, and have been appointed as Commissioner, and in that capacity I chair the Commission. On my right is Ms. Jill Marcus, former Governor of the Reserve Bank, and on my left is Mr. Emmanuel Lediga, to whom we refer as Chief, an investment banker and asset manager. So we have two quite experienced people in what we are going to investigate. They have been appointed by the President to assist the Commissioner in this inquiry. The processes and proceedings relating to the Commission will be governed by the regulations of the Commission, which were published in Government Gazette number 42076 of 3 December 2018, as well as the Commission's Rules of Procedure, which were published in Government Gazette number 42157 on 15 January 2019. The Commission's terms of reference, regulations, and rules of procedure can be accessed on the Commission's website at www.justice.gov.za/commissions/PIC. And at some stage, I hope that website will be reflected on the board behind us. Is it there? I'm told that it is there. As to the Commission's terms of reference, I think it will be convenient to read the instructions in paragraphs 1.1, 2, and 4 thereof. 1 reads as follows: the Commission must inquire into, make findings, report on, and make recommendations on the following. 1.1, whether any alleged impropriety regarding investment decisions by the PIC in media reports in 2017 and 2018 contravened any legislation, PIC policy, or contractual obligations and resulted in any undue benefit for any PIC director or employee or any associate or family member of any PIC director or employee at the time. Paragraph 2 reads, the Commission must, in its inquiry for the purpose of its findings, report and recommendations, consider the period 1 January 2015 to 31 August 2018. So we will not only look at the media reports of 2017 and 18, but we are instructed to go back and start from the 1st of January 2015 and until 31 August 2018. Paragraph 4, the Commission may, if necessary, investigate and make findings and recommendations on any other matter regarding the PIC, regardless of when it is alleged to have occurred, on condition that such other investigations, findings, and recommendations do not cause any delay in the submission of the reports on the applicable dates referred to in paragraph 3. And if I might just mention paragraph 3, the Commission is required to submit an interim report to the President by not later than 15 February 2019 and a final report by not later than 15 April 2019. We are this morning about to commence with the hearing of evidence from witnesses in relation to the issues the Commission has been instructed to investigate and for which it was set up. The Commission, through its Secretary, Advocate Sitati, has sent out notices which again may be accessed on or from our website, inviting anyone with information relevant to the terms of reference to come forward to assist the Commission in its task. Responses to that call have been received, but the invitation still stands. I want to repeat the invitation and invite any person with information that may be relevant to the Commission's terms of reference to contact Advocate Sitati or the evidence leader, Advocate Libber SC, in this regard. The contact details are available on the Commission's website. In fact, Advocate Sitati and Advocate Libber are both here. If anyone wishes to get in touch with them during the adjournment, may do so. For persons who would like to come forward with information relevant to the Commission's terms of reference, and please mark that I repeat, information relevant to the terms of reference of the Commission, but who are afraid to do so for fear of whatever kind of repercussions, there is provision in the regulations for an order that a witness's identity should under no circumstances be disclosed. So there's provision for whoever would not like his or her identity to be disclosed. There's provision for that in our regulations. So people should feel free to come forward, and we give the undertaking that witnesses will be treated fairly and with dignity at all times. Before giving evidence, a witness will be required to take the oath or affirm that the evidence they are about to give will be the truth, the whole truth, and nothing but the truth, as is normally done in a court of law. We need to arrive at our conclusions on evidence that we are satisfied is the truth. We have been advised that media personnel have been accredited. If there are any others who require accreditation, please get in touch with the Secretary of the Commission, who If he cannot do it himself, we'll direct you to the correct person. The sittings of the Commission are commencing today, and we will sit from today until Wednesday, and again next week from Monday until Wednesday the 30th, if I'm correct. We will then adjourn for approximately 3 weeks to commence again with hearing evidence on the 24th of February 2019. If there are any questions arising from the comments that I've just made, please direct them to the media team of the Commission, who will clear it with us if necessary. And may I say that witnesses or members of the public who have had or have any interest in the PIC and our Commission are invited, if they so wish, to make recommendations because we are required by the President to make recommendations in our final report. So if there are people who have an interest and who wish to suggest recommendations, we shall consider them if they are sent to us and included if we feel that they should be included in the final report to the President. Thank you. Yes, Mr. Lebo.
Thank you. I said it that way. Thank you, Commissioner and members of the Commission. For the record, I am the Chief Evidence Leader, J. Libber. I'm a Senior Counsel, and I'm assisted by my very able legal team. From my right, Advocates Hue, Monahela, and Muhapi. I'm further assisted by a forensic team who are already busy with the investigations. We plan, Mr. Commissioner and members, to start this morning with formal evidence, setting the legal framework for the Commission and to explain how the PIC operates within this legal framework. I plan to call as the first witness the Acting Secretary of the PIC, Mrs. Vilna Low. May I, with respect, also join you, Mr. Commissioner, in your appeal for people to come forward to assist the Commission in performing their mandate. As you've mentioned in your opening remarks, the Commission is faced with a very, very tight timeline to complete their work, and it will be impossible, in my respectful submission, if the Commission is not assisted by people coming forward. That is our opening remarks, Commissioner. I would ask you for a brief adjournment to enable us to set up the first witness, and if it's convenient for you, can we start at 11 then?
Proceedings are then adjourned until 11 o'clock.
As it is.
We can, but I want my book. I'll take it with
it out? Yeah. Yella on the left. And we are also greatly honored the top management team of the Pices behind her, and if necessary, will also assist with any difficult questions by the Commission.
The name of the assistant again? Mercia?
Monyela. Monyela.
Bonyela.
Monyela. M-O-N-Y-E-L-A. Monyela. M-O-N-Y-E-L-A, Mr. Commissioner.
No, I can't hear. What's the first letter? M for Martin? Or? Okay, got you.
So if we can then proceed to have the witness sworn in. It's done.
Ms. Lowe, what are your full names?
My names are Wilhelmina Johanna Frederica Lowe.
Wilhelmina Johanna.
That's correct.
Frederica. Frederica with a K-A?
Yes, Commissioner.
K-A. Do you have any objection to taking the prescribed oath?
No.
If not, do you swear that the evidence you are about to give will be the truth, the whole truth and nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Mr. Commissioner, can the witness be seated during
Yes,
the
indeed.
testimony?
Indeed.
And may I respectfully ask that I can also be seated while with the proceedings? This is going to take a couple of hours, I think.
Feel free to do so.
Thank you, Mr. Commissioner. Mrs. Lowe, before we start with your evidence, is it correct that this is your first time testifying in a institution like a commission or a court of law?
That's correct.
Is it also correct that your first language is Afrikaans and not English?
That's correct.
Are you comfortable to testify in English?
I am comfortable.
Right. I want you just to relax, and we've prepared a statement for you. Would you have a look at the statement? You can start with that statement, and where necessary, I will interrupt you or the Commission will interrupt you. But you can please carry on with that, and please speak up. I believe there's a bit of a problem with the sound system. So, Mr. Commissioner, if it sounds that we're shouting at you, we were requested to speak up.
Thank you. Thank you, Mr. Commissioner. As I said, I am Wilhelmina Johanna Frederica Lowe, and I prepared the statement in my capacity as the Acting Company Secretary of the PIC. I joined the Public Investment Commissioners on the 1st of September 1996 as a personal assistant to the then Chief Director of the PIC. We were reporting to the National Treasury at that time. Part of my role was to minute meetings of the commissioners and later the PIC board following the corporatization on the 1st of April 2005.
Can I just interrupt you there? Can you just briefly explain to the Commission what was the situation with the commissioners before 94 and what was the change after the formal act of 94?
Of 94. During the time of the Public Investment Commissioners, it was a department of the National Treasury, reporting directly through the Director General to the Minister of Finance, as all the departments within the National Treasury. The commissioners were still appointed by the Minister of Finance, but they were called commissioners. It was not a company. Then after 2005, when we corporatized, the Public Investment Corporation was established as a company under the Companies Act.
There was, in other words, a formal PIC Act.
Yes. Before that, there was also a PIC Act established in 1984 when we took over the Public Debt Commissioners. But that act was still under the name of the National Treasury and not as a company.
Thank you. Please continue.
I was appointed as the Company Secretary of the PIC for the period 1st December 2008 to the 31st of March 2015. From 1st April 2015, I assumed the role of the Board Secretary, responsible for, inter alia, the collection and compiling of board documents, board committee papers, attending board committee meetings, and taking minutes of these meetings. However, I also continued as an acting Company Secretary during that period until Ms. Bongani Matabula was appointed as the Company Secretary on the 1st of August 2015. Then I'll continue just to give a brief overview of the PIC. The Public Investment Corporation SOC Limited is a South African state-owned asset management company that manages assets for clients, all of which are public sector entities. The PIC has a long history which spans over 107 years, although we were corporatized only in 2005. The concept of a separate body responsible for the investment of trust and other government deposits has its origins in the Public Debt Commissioners Act 1911, which came into operation on the 2nd of May 1911. This act was later replaced by the Public Debt Commissioners Act 1969, and the successor of the Public Debt Commissioners was the Public Investment Commissioners, which was governed by the Public Investment Commissioners Act 1984. In April 2005, the Public Investment Corporation SOC Limited succeeded the Public Investment Commissioners. The PIC was promulgated on the 1st of April 2005 in accordance with the Public Investment Corporation Act 2004 as a corporation wholly owned by the South African government and represented by the Minister of Finance as the shareholder representative. As per Section 4 of the PIC Act, the main object of the PIC is to be a financial service provider in terms of the Financial Advisory and Intermediary Services Act 2002, or in short, the FICE Act.
Ms. Lowe, can I, sorry, from here. Can I just go back to the first line of that paragraph 131? You mentioned that the PIC was promulgated on the 1st of April 2005. Somewhere I saw a certificate of incorporation dated, I think, 30 March or something, 2005 or 4. Why is there a difference?
No, sir. I will have to have a look at that.
Yes, all right. All right. I'll have a look during the break.
And I'll come back to you on that as well, sir. We'll have a look at that.
Mr. Commissioner, we make a note of that and we'll come back on that.
Section 10(1) of the PIC Act provides that the corporation may invest every deposit or portions of a deposit with regard to the periodic, if any, after the expiration of which such a deposit or portions of such a deposit may again become necessary for use on behalf of the depositor concerned in accordance with the investment policy of the corporation. Now, the PIC Act further goes on to define deposit and depositor as follows. Deposit means an amount of money other than that forming part of the National Revenue Fund as contemplated in the Public Finance Management Act 1999, which is received or held by, for or on behalf of the Government of the Republic, including the provinces, or any body, council, fund, or account established by or under law, which may or is required to pay in terms of that law such amount of money to the corporation for investment in terms of this Act, and which is not required for immediate use or as a reasonable working balance, and which is not invested or otherwise unlisted in terms of, otherwise utilized in terms of any law otherwise than in terms of this Act, and which is not invested with the corporation referred to in Section 2 of the Corporation for Public Deposits Act 1984, and except for the purposes of Section 11(1), includes an amount of money received or held by, for or on behalf of a person or body referred to in that subsection. A depositor means any person or body who pays a deposit to the corporation for investment on behalf of the person or body and is for the purposes of the FICE Act deemed to be a client as defined in Section 1(1) of the FICE Act.
Ms. Lowe, I know very little about investment and so on, but can an individual just walk into the offices of the PIC and say, I've got money to invest?
Not at this stage, sir. Mr. Commissioner, the PIC Act doesn't provide for public people to invest with it at the moment. The PIC Act further provides in Section 11 that the Minister may, if it is in the public interest, authorize generally or in respect of a particular case, any person or body receiving or holding within or outside the Republic amounts or money other than deposits to pay those amounts or money or portions thereof to the corporation for investment as if those amounts or money were deposits. The corporation may receive for investment amounts of money other than deposits and those amounts contemplated in subsection 1. Then I'll give a bit background about the regulatory environment. The PIC is a South African state-owned asset management company that manages assets for clients, all of which are public sector entities. The PIC as a state-owned entity is governed by the following laws, which is the major laws for the PIC. That is the Public Investment Corporation Act 2004, the Companies Act 2008, and we were registered under the Companies Act as a company with company registration number 2005 00909430, and then the Public Finance Management Act 1999. The PIC is scheduled as a 3B entity under the PFMA and reports to the Minister of Finance in terms of the PFMA. In addition to the provisions of the PIC Act, the operations of the PIC is supported by the establishment of legislation for some public entities, which specifically direct these entities to invest the monies which are not required for immediate use with the PIC. Furthermore, in terms of the Treasury regulations issued in terms of the PFMA, public entities that are listed in Schedule 3A or 3C of the PFMA must invest their surplus funds with the Corporation for Public Deposits unless they are exempted by the National Treasury. All the Schedule 3A and 3C companies were exempted by the National Treasury, and therefore they can invest their funds now with the PIC. The PIC as an asset manager, as a financial services provider with financial services provider number 1977, the PIC is registered with the Financial Sector Conduct Authority, that was previously the Financial Services Board. The PIC's investment activities are governed by the Financial Advisory and Intermediary Services Act 2002. The PIC's FICE license status. The FICE Act provides for regulation of financial services or various categories of financial services providers. The PIC is licensed for 2 categories, namely Category 1 as an advisory and intermediary service financial services provider. That means that FSP is providing financial advice to clients without discretion to decide on behalf of the clients. The PIC may be requested to provide input into the client's mandate in relation to asset class allocations with a view to assist the client in achieving its investment objectives. PIC is also registered as a Category 2 advisory service, financial service provider, which is a discretionary financial service provider. Under this category, the PIC is authorized to make investment decisions, buy or sell assets on behalf of its clients.
When you say discretionary, what do you mean thereby?
We make investments on behalf of the client without first getting the input from the client or approval from the client. It is totally in line with the client mandate, but then we can decide what to sell and what to buy. An FSP means any person, natural or juristic, who as a regular feature of the business render financial advice and or intermediary services in respect of financial products, which is asset classes, to clients or on behalf of clients. Then our client investment mandates are also regulated by the FICE Act. The clients, for example, the Government Employees Pension Fund, has provided the PIC with an investment mandate that are approved by the regulator, the Financial Sector Conduct Authority. The mandate sets out, amongst others, the investment objectives, risk appetite, and the asset classes, allocations, or parameters. The PIC is responsible for formulating investment strategy on how to achieve the client's investment objectives and returns set out in the mandate, taking into account the guidelines stipulated in the mandate.
Perhaps I can intervene here for a moment, Mr. Commissioner. The biggest client of the PIC, I understand, is the GEPF, the Government Employees Pension Fund.
That's correct.
And the PIC will then get a mandate from the Board of Trustees of this fund.
That's correct.
Right. Thank you. Please proceed.
For purposes of ensuring compliance with the client mandates, in particular adherence to the asset class allocation limits, the PIC utilizes the Charles River Investment Management System and the High Portfolio System to capture the client mandates and monitor compliance thereof.
Can you, just for the moment, with your leave, Mr. Commissioner, just tell the Commission what are you talking about when you talk about the Charles River Investment Management System and the High Portfolio System? What is it exactly about?
Mr. Commissioner, if I may, I am not very familiar with exactly what the Charles River Investment Management System is, but in short, I just know that is where the performance of the investments are captured. And I think my colleagues will elaborate on that if you are in agreement with that.
Mr. Commissioner, I've made a note of that. The next witnesses will be the executive managers' investments, and we'll make an issue to explain that properly to the Commission.
Thank you. In terms of the FICE Act, the PIC are required to have key individuals, investment professionals, and the PIC currently has 69 investment professionals registered with the FSCA that are approved to make investment recommendations and decisions in respect of investments in various asset classes on behalf of the clients, in line with the client's mandates and the delegation of authority, which sets out the limits for approval of transactions and deals. The investment professionals are required to meet the following FICE fit and proper requirements before registration with the FSCA. competency requirements, which include experience, qualifications, regulatory examinations, continuous professional development, and class of business training. And then there's an element of honesty, integrity, and good standing, which they need to meet. Key individuals provide oversight and manage the rendering of financial services, while the representatives make investment recommendations or decisions in respect of investments in various asset classes on behalf of PIC clients. PIC reporting to clients. The PIC reports to clients on a monthly and quarterly basis, detailing amongst others portfolio performance during the investment period. The clients are further able to engage with the PIC during the presentations of the portfolio performances and sought clarity if needs be. PIC submissions and reporting to the regulator. In terms of the FICE Act, the PIC provides the following submissions to the regulator: audited annual financial statements. Then there's a FICE Section 19.3 report, which provides a list of investments and reconciliation of the bank account statements held in the name of the clients and the investments made. The FICE biannual compliance report, which entails a set of self-assessment questions seeking to establish and determine the PIC's level of compliance with the FICE Act. And then registration and updating of the key individuals and representatives registers with the FSCA as and when there are new appointments and resignations, and then applying for profile changes with the FSCA as and when there are new appointments or resignations of members of the PIC Board of Directors.
Mr. Commissioner, if I can again interrupt, the next paragraph deals with all the other applicable legislation. Can it be just noted? I don't think it's necessary for the witness to read that out. It may take an hour. So with your permission, can't you then proceed with paragraph 3?
Yes, may I just mention that we have been provided with copies of the statement that Ms. Lowe is reading from. But later on it will be officially handed up. It's just so that we can follow the proceedings. I'm fine with that, Mr. Libber.
Thank you, Mr. Commissioner.
We can leave out going through the list of acts.
Thank you, Mr. Commissioner. Then I'll get to PIC's vision and mission. The PIC is an organization with values that the corporation's leadership, management, and employees have agreed to strive for and live by in order to achieve the vision, mission, goals, and objectives of the company. Now, PIC's mission is to be a global leader in impactful investing. Sorry, that is our vision, to be a global leader in impactful investing. Our mission is to exceed clients' expectations whilst investing for sustainable growth, inclusivity, and transformation. To grow the client base and investment offerings through innovative thinking, mobilizing and leveraging strategic partnerships and resources, and to be a catalyst of continental economic integration and global investor. Now, in order for us to achieve our vision and mission, we implemented optimal information technology. We invest in our people and creating brand ambassadors. We entrenched ESG, which is environmental, social, and governance practices. We strive for innovative culture and implementation thereof, insightful research and enterprise intelligence, and we believe in robust risk management. PIC's values.
Just a moment. My colleague has a question.
The one question is on impactful investments. Do you perhaps have any benchmark companies that you use to compare yourself with those in terms of the impact of investments that you make?
Thank you, Mr. Commissioner. Through you, I will, if I may again, just get the full details of the companies, if we use any companies, and then I'll come back to you after the break on that one. Thank you. Okay, PIC's values are we care and we deliver, and those form the cornerstone of PIC's culture. Then PIC's business operating model. PIC is different from development finance institutions in that the PIC is an asset manager which manages funds based on mandates prescribed by clients for which it is paid a fee. PIC does not own these investments. The DFIs, on the other hand, manage funds from their own balance sheet.
Can I again interrupt just to explain to the Commission? The Development Bank of South Africa is, in other words, a development finance institution.
That's correct.
And that differs from the PIC. Is that correct?
Yes.
Thank you.
Whilst the PIC's investment philosophy includes consideration of developmental impact, it has to deliver financial returns in line with client mandates and expectations. The development finance institutions have the latitude to sacrifice financial returns in order to achieve social impact outcomes, and primarily exist because of the failure of commercial financial institutions to intervene in certain markets. The PIC business model can be summarized as follows. The PIC invests funds as allocated by clients. The clients pay management fees to the PIC. The management fees are the major source of the PIC's income and finances its operations. The PIC investment activity and implementation of the strategy are guided and overseen by the board. In doing business, the PIC interacts with the investee companies, government, in terms of the alignment of developmental and sectorial priorities, such as the National Development Plan, service providers, which provide specialist services, strategic partners, crowding in of private sector funding and co-investments in implementation of the client mandates.
Mr. Commissioner, can I again interrupt here? Can you just explain to the Commission the management fees that you refer to in 5.2 bullet 1? Is it a fixed percentage? Is it an agreed fee? What is the situation?
Through you, Mr. Commissioner, the management fees are agreed upfront with the client in the client mandate, and it differs from the different asset classes and the different portfolios. For the unlisted investments, the management fees are between 25 basis points and 150 basis points. That is across all our clients, the top 3 clients specifically. For the property investments, it is a fixed fee of 25 basis points, and for the listed investments portfolio, the management fee is between 1 and 3 basis points.
Thank you.
Then corporate governance at the PIC Board of Directors. Section 6.1 of the PIC Act 2004 provides that the minister must, in consultation with Cabinet, determine and appoint the members of the board. Paragraph 7 of the PIC's Memorandum of Incorporation stipulates that the board shall comprise of no less than 10 and no more than 15 directors. Section 7 of the PIC Act further empowers the board to establish such committees as it considers necessary. And the PIC Memorandum of Incorporation provides that the Chief Executive Officer the Chief Financial Officer, the Chief Investment Officer, and the Chief Operations Officer of the PIC shall be appointed as ex officio executive directors of the company. The current board of directors,
I assume, Mr. Libber, we will hear later what these individuals do.
Exactly, Mr. Commissioner.
in the current board of directors, Mr. Mondli Gungubele, the Deputy Minister of Finance, is the chairman. Dr. Kulani Mkwanazi has been appointed as the Deputy Chairman of the board. Then our non-executive directors are Ms. Dudu Schlatswayu, Dr. Truman Goba, Ms. Sandra Beswick, Ms. Lindiwe Toi, Mr. Pitsi Mulotu, Ms. Matukana Makoka, and Ms. Sibusisiwe Zulu. We currently have only one executive director, which is Ms. Matsepu More. The appointment process, the company secretary receives nominations accompanied by a curriculum vitae of potential non-executive directors and keeps a database of the names for consideration for appointment to the PIC board. These nominations are submitted by board members, the public, PIC employees, or the PIC clients. The company secretary liaises with the Asset and Liability Division of the National Treasury on the rotation of existing non-executive directors, the reappointment of eligible non-executive directors, and the appointment of new non-executive directors. A memorandum nominating persons for appointment as non-executive directors are then compiled by the company secretary in consultation with the CEO, and once signed off by the CEO, the PIC's nominations for appointment as non-executive directors to the PIC board is submitted to the shareholder representative through the office of the chairman of the board. I just want to let the Commission know that these nominations for appointment to the board do not serve at any of the PIC board committees. It is dealt with by the company secretary, the CEO, and the office of the chairman of the board. The office of the shareholder representative.
Just give us a moment. Just give us a moment.
To your knowledge, given that all of these appointments are made by Cabinet in consultation with the Minister of Finance, has there been any instance where the Cabinet has proposed names or rejected names that have been proposed?
Through you, Mr. Commissioner, at the end, we don't see the Cabinet memorandum which is submitted to the Cabinet, but the Minister can exclude some of the PIC's nominations and include his own nominations. And as I understand the process, that even at the Cabinet Committee and at Cabinet, some of the proposed names can be rejected and new ones can be added to the list.
Added by whom?
By the Cabinet Ministers or the Minister of Finance.
So in essence, the board as it exists does not really have any influence over new members coming in or requirements for that would strengthen the board. It is a Cabinet ministerial decision.
Yeah, that's correct. We can propose, but at the end of the day, the board doesn't have any say in who is appointed.
If I can again assist, Mr. Commissioner, as I understand it, and Mrs. Lowe, please listen carefully what I'm saying. As I understand the situation, the memorandum by the board of nominations are handed by the chairperson to National Treasury, who will consider those names, but in their discretion can leave them out or add to them. They will prepare a final memorandum going to Cabinet, who will then have the final say who to appoint as board members. Is that correct?
That's correct.
Another question here?
Yeah, two questions. You mentioned that nominations can be done by the general public.
That's correct.
How is that achieved in terms of getting the general public to make nominations, as the first question? The second question, if you get, say, 500 nominations, who actually whittles down that particular list? Is it done at the PIC level or at the National Treasury level?
Through you, Mr. Commissioner, the PIC has previously advertised requesting nominations from the public, and the National Treasury are also advertising, as I understand. I unfortunately cannot confirm that as a fact, but as I understand, they are also advertising, put out advertisements for the public to submit names. They are compiling their own list for nominations, and we are compiling our list for nominations as well. And then if we get, for instance, the 500, if they were submitted to us, we go through it, we look at the qualifications, the skills that are needed on our board, and we compile our list in terms of that.
Appointment process.
That's the appointment process. Now, the chairman of the PIC board. The chairman of the board, who is also the Deputy Minister of Finance, is appointed by the Minister of Finance in consultation with Cabinet. The King Report on Corporate Governance for South Africa, as amended from time to time, prescribes that the board chairmanship should preferably be held by an independent non-executive director. However, the appointment of the Deputy Minister as chairman of the PIC board is based on the fact that the Government Employees Pension Fund, who is our biggest client and constitutes approximately 88% of the PIC's funds under management, is a defined benefit fund underwritten by government, with the Minister of Finance as the shareholder representative. To ensure that there is a proper balance of power to strengthen the independence of the board and to lead in the absence of the chairman, Dr. Kulani Mkwanazi has been appointed as the lead independent non-executive director, which is in line with the King report as well.
But there is nothing in the legislation, in any legislation is there, that the chairman or chairperson of the board must be the Deputy Finance Minister?
Now, Commissioner, it's not legislated.
And in addition, is this the first time with Dr. Mkwanazi that you have a lead independent non-exec director, or has that been practiced in the past?
We had one previously. It was Mr. Rushan Morar. So Dr. Mkwanazi is our second lead independent director. In the rotation of directors, in terms of the PIC MOI, a non-executive director shall hold office for a term of 3 years and shall not hold office for more than 2 consecutive terms. A non-executive director who has been in office for 3 years since his or her last appointment shall retire during the annual general meeting. 1/3 of the non-executive directors for the time being, or if their number is not a multiple of 3, then the number nearest but not less than 1/3 shall retire from office. The non-executive directors retiring shall be those who have been longest in office since their last appointment.
Perhaps just a question of past practice. The term of 2 consecutive terms, so a total of 6 years.
That's correct.
Was that different in the past? Was there a term limit? And secondly, given the complexity of what the PIC does, I fully agree there should be term limits, but 6 seems a little sort of in between, not long enough and a bit too short. What would motivate a 2-term rather than a 3-term?
Since the incorporatization, it was always a term of 6 years, maximum 6 years. After 3 years, they rotate and then they are reappointed by Cabinet, or Cabinet can decide not to reappoint them. With regards to the limited term of 6 years, all the state-owned entities that are reporting to the Minister of Finance basically have that provision. That was always the shareholders' provision, that we have our directors only for a period of 6 years to ensure independence. It is also aligned with the King that says independence is basically for 6 years, but it can be prolonged to, in certain circumstances, to 9 years. If I may, Mr. Commissioner, then the non-executive directors' fees. The fees are paid in terms of Section 66(9) of the Companies Act, which provides that fees paid to non-executive directors for their services as directors may be paid only in accordance with a special resolution approved by the shareholder in the previous 2 years. The shareholder considered this and signed the latest special resolution in line with the provisions of the Companies Act at the annual general meeting held on 8th of June 2018.
May I just again interrupt for clarity purposes, Commissioner? The non-executive directors, are they paid per hour? Are they paid for preparation for meetings, or are they just paid per meeting? Can you just put that on record?
Sure, through you, Mr. Commissioner, the non-executive directors are paid a meeting fee. They are paid per meeting. They are, and as well as a retainer fee, which is paid once per annum. The meeting fees are paid for board attendances at board meetings, and then a different fee for attendances at committee meetings. They are not paid any additional incentives, bonuses, and the retainer fees are also there for preparation time and for documentation which they had to make for their own account. The PIC Memorandum of Incorporation. The Memorandum of Incorporation sets out the rules governing the conduct of the company as specified by its owners, the shareholder. Section 15 of the Companies Act imposes certain specific requirements on the content of a MOI as necessary to protect the interest of the shareholders in the company, and provides for a number of default company rules or alterable provisions which companies may accept or alter as they wish, as long as it is in line with the Companies Act. The PIC's MOI was signed by the then shareholder representative, Mr. Pravin Gordhan, on 26 April 2013. Mr. Gordhan requested changes to the PIC MOI in his letter dated 24 March 2017 and signed the amended MOI on 30 March 2017. Mr. Gigaba was appointed as the Minister of Finance on 30 March 2017, after which he requested the PIC board in his letter dated 19 April 2017 to ensure that the MOI signed by Mr. Gordhan on 30 March 2017 is not implemented, and that the 2013 MOI should remain in existence until he has acquainted himself with the PIC. This request was then accepted by the Companies and Intellectual Property Commission on 15 May 2017.
Now, which one should we look at?
The one dated 26 April 2013.
Mr. Commissioner, if I again may intervene, if the Commission will please just make a note of this part of the evidence, as further evidence will be led later in these proceedings regarding the withdrawal of the MOI.
Then paragraph 6.3 is the Shareholders' Compact and Corporate Plan. In terms of sub-regulation 29.2 of the Treasury regulations issued in terms of the PFMA, the PIC must, in consultation with its executive authority, the Minister, on an annual basis conclude a shareholders' compact documenting the mandated key performance measures and indicators to be attained by the PIC as agreed between the board and the minister as the accounting authority. The shareholders' compact represents the agreement between the executive authority and the accounting authority and is a reflection of the expectations of each party expressed in terms of outcomes and outputs that need to be achieved. The corporate plan is a framework containing information regarding the corporation's strategic thinking, direction, and action leading to the achievement of consistent and planned results. The corporate plan is designed to support the leadership within the corporation through the concise presentation of the outcomes of strategic planning and budgeting at operational level. In terms of the corporate plan and the shareholders' compact, the PIC is reporting on a quarterly basis to the National Treasury on the achievement of the targets set out in the corporate plan. Then PIC is operating under a delegation of authority. The board retains effective control over the operations of the PIC through well-developed governance structures, comprising various board committees and a comprehensive delegation of authority. The delegation of authority ensures timeous and effective implementation of the board strategy, but does not divest the board of its responsibilities. The DOA delegates responsibilities for different transactions to a variety of role players in the investment divisions, which includes the listed, unlisted, and property investments, as well as to employees within the risk management, legal, compliance, corporate affairs, and investment support departments. The DOA also sets out the powers of the board and the different management committees. The board has put 4 delegation of authority documents in place, which is the corporate delegation of authority, the unlisted investments delegation of authority, the property investments delegation of authority, and the listed investments delegation of authority. PIC is also adhering to a number of policies. PIC's policies and procedures are designed to influence, determine, and guide all major decisions and actions. And then I've included a list of the policies which are currently in place as per the different departments. The company secretariat has the Board of Directors Code of Conduct and the remuneration policy for non-executive directors. The Human Resources Department is the bursary policy, the Code of Ethics policy, conditions of service policy, disciplinary policy and procedure. We've got a dress code policy, education assistance scheme, a leave policy, performance management policy, the PIC or the PIC policy, the recruitment policy, remuneration policy, sexual harassment policy, and the training policy.
If I can then again intervene, Mr. Commissioner, the important policies and reflected in the terms of reference, which we'll come back to later, are the Code of Ethics policy, the Performance Management policy, the Recruitment policy, Remuneration policy, dealing with incentives and bonuses. We will later present evidence on those policies. Thank you.
Thank you, Mr.
Shouldn't we have access to the disciplinary policy and procedure as well?
Absolutely, it is available, and when we deal, we'll specifically deal with 1 or 2 instances where the disciplinary policies are applicable.
Thank you, Mr. Commissioner. Then our Corporate Affairs Department are responsible for the language policy, the news and social media policy, and the stakeholder management policy. The Finance Department is the corporate procurement policy, the dividend policy, the Isibaya procurement policy, the petty cash policy, properties investments procurement policy, and the travel policy. Information technology is the acceptable use policy, the IT disposal policy, and the third-party management policy. Our records management, we have the records management policy.
Can you just give us a moment?
Just a question on dividends. Has the PIC ever paid a dividend to the government, to the National Treasury?
Yes, Mr. Commissioner, the PIC has declared, I think now 3 or 4 dividends to the National Treasury already. Our records management.
Sorry, Mr. Commissioner, can I just ask, would you prefer to have documentary evidence available of those dividends? Thank you.
But the amounts might be relevant.
Okay, we'll get the amounts for you, Mr. Commissioner. The Records Management Department, we have the Records Management Policy and the Records Retention Schedule for PIC. In our Compliance Department, we've got an anti-money laundering policy, client complaints resolution policy, the Compliance Charter, Compliance Framework and Manual, Conflict of Interest Management Policy, Debarment Policy, Personal Account and Insider Trading Policy, Risk Management and Compliance Program, and Treating Customers Fairly Policy. Then within
Advocate Libber, I suspect that virtually all these would be relevant, isn't it?
It's absolutely correct, Mr. Commissioner, yes. We will deal with that specifically when we deal with specific investments.
In risk management, we've got the credit risk policy, enterprise risk management framework, mandate compliance and statistic data management policy, mandate compliance policy, market risk policy, operational risk management framework, and a standard operating procedure for performance and attribution.
Also, Mr. Commissioner, highly relevant to later evidence.
We've also got the safety, health and environmental policy, and then for listed investments, they are responsible for the dealing policies, procedures, fixed income policies and procedures, listed equities trade allocation policy, and they've also got a standard operating procedure for listed investments. Investment management is the asset apportionment policy, asset disposal guidelines, BBEE policy for listed investments, BBEE guidelines for the Isibaya investments, delisted investment policy, ESG guidelines for external managers, an ESG policy for fixed income, ESG policy for listed equities, ESG policy for public entities, an ESG policy for unlisted investments, a governance policy, and a political exposed persons policy.
Again, if I may interrupt, Mr. Commissioner, highly relevant. You will notice in the terms of reference that specific reference is made to politically exposed persons for this Commission's investigations.
Thank you, Mr. Commissioner.
Just a question here.
Yeah, I'm not sure. Looking at this list, there should have been, maybe there's a whistleblowing policy somewhere, but I'm not sure whether is it part of that or what.
Yes, Mr. Commissioner, the whistleblowing policy is part of our compliance policies, and it is dealt with in terms of the personal account and insider trading policy. It also making reference to it in our code of ethics. So there is definitely a whistleblowing hotline as well. That deals then with the policies. Then just to say that our external auditors, as the PIC is classified as a Schedule 3B entity in terms of the Public Finance Management Act, we are audited by the Auditor General in terms of the PFMA, the Auditor General Act, and paragraph 683 and 18.1 of PIC's Memorandum of Incorporation. In the governance structure, the board established the following board committees to assist with balance of power and the effective discharge of its duties. The committees regularly report to the board in terms of their agreed terms of reference, which are reviewed annually to ensure relevance and alignment with governance best practice. We've got the Audit and Risk Committee. The Audit and Risk Committee is a statutory committee in terms of Section 94 of the Companies Act and provides oversight of audit, compliance, and risk management. The members of the Audit and Risk Committee are appointed at the annual general meeting by the shareholder in line with the provisions of the Companies Act. Here, if I can perhaps explain, while the PFMA is also applicable to the PIC, the National Treasury gave the PIC exemption from the Public Finance Management Act, because in terms of the Public Finance Management Act, the board appoints the members of the Audit Committee, whilst in the Companies Act, the shareholder appoints the members of the Audit Committee. My apologies, I did not include that in my written statement. Then there's the Social and Ethics Committee.
Before you proceed, if I again may interrupt, Mr. Commissioner, the 4 names listed under 6.71, just for the record, they are all board members.
They are all non-executive board members. The Social and Ethics
Just a question in relation to the size of your audit and risk, and given that the audit and risk are combined, has the PIC looked at whether this is an adequate capacity for oversight, given the complexity and the issues at stake in relation to both risk and audit, to have such a small audit committee?
Through you, Mr. Commissioner, the Audit and Risk Committee was previously consisted of 6 members, but 2 of our non-executive directors resigned during April or June, July. And then when at our annual general meeting held on the 8th of June, the shareholder only appoints these 4 people, but we agree that the span of control and the span of the duties of the Audit and Risk Committee are very broad, and there is a process underway where we are considering separating the Audit Committee and establishing a Risk Committee, especially for the purposes of the
I mean, I think that's interesting to hear, because the skills required for a risk committee are somewhat different. And with such a narrow team, given audit and risk together and the skills required, I would think that this certainly would require some attention. I mean, it just raises a question being such a small committee.
Yes. Noted. Thank you, Mr. Commissioner. We will note that down.
Just a further question is that how was it decided that this committee will be appointed by the board, not the shareholder? How was that decision?
Now, sorry, Mr. Commissioner, the committee is appointed by the shareholder and not by the board. The PFMA states that the board must appoint the audit committee members. But the Companies Act stated that the shareholder shall appoint the audit committee members. And then after discussions with the National Treasury, the National Treasury exempt the PIC from adherence to the PFMA. So the shareholder is now appointing the audit committee. The audit committee.
Clear now. Thank you.
That's
Thanks.
Social and Ethics Committee. Regulation 43 of the Companies Act requires that all state-owned entities must have a Social and Ethics Committee. Regulation 43 further sets out the duties and responsibilities of the Social and Ethics Committee, and Section 72(8) of the Companies Act provides the powers for the Social and Ethics Committee. The Social and Ethics Committee currently consists of Ms. Lindiwe Toi, Mr. Pice Molotu, Ms. Matukana Mokoka, Dr. Kulani Mkwanazi, and Ms. Matsepu More.
Just for the record again, Mr. Commissioner, and for the benefit of the Commission, this type of committee is a result of the King IV recommendations. Previously, there were no such committees in the company sphere, but these are coming out of the recommendations of King IV.
Then there's the Directors' Affairs Committee. The Directors' Affairs Committee serves as PIC's nominations committee and focuses on board evaluations and nominations for appointments to the boards of PIC investee companies. The membership of the Directors' Affairs Committee comprises the chairpersons of the board committees as well as the CEO. The Human Resources and Remuneration Committee ensures that formal and transparent procedures are followed, especially in terms of PIC's remuneration policy and other labour relations matters.
Can I just again interrupt? We will present more detailed evidence regarding the working of this committee, especially with the view of the terms of reference of the Commission, where there are, the Commission is required to look into this alleged unfair salary increases, payment of bonuses, incentives, etc.
And if I can also mention there under the Human Resources and Remuneration Committee, all of the members there are also non-executive directors. No executive director or a member of the HRRC. Information, Communication and Technology Governance Committee. If I may, I'm going to refer to it as the ICTGC, is constituted in terms of Principle 12 of the King Report, with its focus being on information technology governance and information and cyber security. Here we've got 4 non-executive directors and 1 executive director. The Investment Committee provides an oversight and decision-making on investment activities and is chaired by a non-executive director as well. Then we've established fund investment panels as subcommittees of the Investment Committee. The fund investment panels have the authority to deliberate and make investment decisions on unlisted investments, including properties or real estate, in accordance with the approved unlisted investments DOA, the property investments DOA, and approved private placement memorandums. The fund investment panels further act in accordance with and subject to the authority, directives and requirements that may be laid down by the board and the IC. The Property Fund Investment Panel assists the Investment Committee with oversight of direct and indirect unlisted property investments. The Social and Economic Infrastructure and Environmental Sustainability Fund Investment Panel assists the Investment Committee with oversight of unlisted social and economic infrastructure investments, and the Private Equity, Priority Sector and Small Medium Enterprise Fund Investment Panel assists the IC with oversight of the private equity, priority sector and small medium enterprise investments. All of these fund investment panels consist of the majority of non-executive directors, and the only other membership is the Chief Executive Officer.
Financial officer.
Chief Executive. Then we've provided a schematic illustration of the Board of Directors and how the different committees fit into the board.
That's fine, carry on.
The Executive Committee. The CEO is responsible for the day-to-day management of the PIC in line with the board-approved delegation of authority framework and the strategic direction set by the board. The CEO is assisted by an executive committee, or Exco, whose functions is to assist the CEO in effectively discharge his or her statutory duties in managing the PIC. The Exco is governed by all applicable laws as well as approved terms of reference and the delegation of authority. The Exco comprises the following members: the Chief Executive Officer, who is the Chairman of the Committee, the Chief Financial Officer, the Executive Head, Research and Project Development, the Executive Head, Impact Investing, the Executive Head, Private Equity and SIPs, that is Structured Investment Products, the Executive Head, Property Investments, Executive Head, Listed Investments, Executive Head, Investment Management, Executive Head, Human Resources, Executive Head, Risk, the Executive Head, Legal Counsel, Governance and Compliance, and the Executive Head, Information Technology. Then there are a couple of permanent employees or permanent invitees to the Exco meeting. They do not form part of the quorum and they have no decision-making powers. That is the General Manager Finance, the Executive Assistant to the CEO, the Head of Internal Audit, the Head of Corporate Affairs, and the Company Secretary. The Exco has established a number of subcommittees in line with the investment strategy to instill a culture of compliance and good governance and to ensure that the PIC's governance process and affairs are conducted with accountability, transparency, fairness, and prudence. Each subcommittee operates in accordance with an Exco-approved terms of reference, the delegation of authority, and the approved policies.
I note that there's a word missing in 6.8.4. Can I take it that integrity is also included in that?
That is true, Mr. Commissioner. The first committee is the Information Technology and Risk Committee. The committee provides oversight of IT information technology related activities of the PIC as recommended by the King Report and ensures that an appropriate enterprise risk management framework is in place and operates effectively. This committee reports through the Executive Committee to the Audit and Risk Committee, the Social and Ethics Committee, and the ICTGC Committee. Then we've got the Finance and Valuations Committee that reviews the inputs, assumptions, valuation, and methodology and calculates fair values of listed and unlisted investments for reporting to clients. The committee also submits the valuations to the Investment Committee for approval. The Employment Equity Committee, the Exco recognizes that from a business and transformation perspective, it is important to entrench employment equity in the workplace and to comply with the requirements of the Employment Equity Act 1998.
My colleague has a question here.
Just in terms of the Finance and Valuations Committee, is it a self-standing committee or is it within the various departments, when people do valuations? I don't know if I'm clear.
Mr. Commissioner, if I can just, if you say a standing committee or in the different departments.
Yeah, so is it
Okay. Mr. Commissioner, the Valuations Committee consists of the different executive heads as well as finance, but the PIC has independent external service providers who value all PIC investments. So it is not done, it is done internally by the risk department and the different investment departments, but the final valuation is done by the external valuers, which is then presented to our investment committee, first to the Finance and Valuations Committee, then it is presented to our investment committee, and then to the different clients.
if you have to invest in a company, the final valuation, where does it come from?
Okay, so if I can, these valuations are done at financial year end. It's done after PIC has made the investment. When we are going to invest in a company, that valuation is done during the due diligence process, which will be explained later on by the executive heads in investments. But that valuation is not going through the Finance and Valuations Committee.
Or the year-end valuations are the ones that are done in this committee.
In this committee, that's
the individual valuations are done somewhere else.
That's correct.
All right. Thank you.
To continue with the Employment Equity Committee, the Employment Equity Committee derives its mandate from constituencies and relevant labour legislations, and the membership is 2 co-chairpersons, 1 representing management and 1 representing the employees. Then we've appointed 4 employer representatives, 4 employee representatives, and we have 1 representative from differently abled people on the committee. The Portfolio Management Committee for Unlisted Investments is responsible for the oversight of implementation of PIC's investment strategy for unlisted investments and approval of unlisted investments, including properties, in line with the delegation of authority for unlisted investments and for property investments, as well as approved policies. The membership of this committee is all executive heads and the Chief Investment Officer and Chief Financial Officer. The Portfolio Management Committee for Listed Investments is responsible for oversight of implementation of PIC's investment strategy for listed investments, approval of listed investments in line with the DOA, and listed investments and approved policies. This committee also looks at listed properties.
If I can again intervene, if the Commission will just make a note, these are 2 very important committees that will be more fully explained when we deal with specific investments.
Then we've got the Asset Allocation Committee. The Asset Allocation Committee was established in 2017 with the responsibility to determine and implement a tactical asset allocation strategic investment approach or framework for listed, unlisted, and property investments adopted by Exco. Part of the Asset Allocation Committee's responsibilities is the screening of unlisted investment proposals received by the PIC through a deal screening task team before submission to the Portfolio Management Committee unlisted investments for consideration to proceed to the due diligence phase to ensure alignment to investment strategy. The membership of the Asset Allocation Committee are very broad and comprises a variety of employees at different levels within the PIC. It includes the deal teams, the executive head research and project development is the chairman of this committee. The chief executive officer and the chief financial officer are members, as well as the executive heads for the listed departments like listed investments, investment management, private equity and SIPs, impact investing, property investments. The executive head of risk are also a member to look after and ensure that the risk is taken into account during the deliberations. The head economic research, head investment projects, the senior specialist, those are all the people who basically receives the investments and then work further on the investments. Then it's just a schematic, again, of the Exco with the different committees, how each one fits in and how it is divided between PIC corporate and assets under management. Conflict of interest. Conflict of interest means any situation in which the PIC employees, representatives, key individuals, or a director has an actual or potential interest that may, in rendering a financial service to a client, influence the objective performance of their obligations towards such a client, prevent the PIC as provider, representative, key individual, or director from rendering an unbiased and fair financial service to that client, or from acting in the interest of that client, including but not limited to a financial interest, an ownership interest, and any relationship with a third party. A conflict of interest may be actual, perceived, or potential as outlined below. An actual conflict of interest occurs when there is a conflict between a director's official duties and their responsibilities in serving the PIC's interest and their personal interest. A perceived conflict of interest occurs when a reasonable person, knowing the facts, would consider that a conflict of interest may exist, and a potential conflict of interest occurs where a director has a personal interest that could conflict with their official duties in the future. Please note that even though the following process refers to directors, the process applies to all PIC employees, representatives, key individuals, and the directors. The only difference is that the directors submit their declarations to the board through the office of the company secretary, while the PIC employees, representatives, and key individuals submit their declarations to the executive head of human resources.
Do board members also submit conflict of interest statements and declarations?
Yes, through you, I am coming to that part now, Mr. Commissioner. Where a conflict of interest has been identified, full and timely disclosure in writing of any conflict or potential conflict relating to directors must be made to the board through the company secretary. The board requires full transparency about the nature and details of any actual, perceived, or potential conflict of interest. At the beginning of each financial year, directors are required to submit a duly completed and signed declaration of interest form to the company secretary. The company secretary also obtained the directorships of individual directors from the Company and Intellectual Property Commission website. The directors are the board members.
Just with regard to the question posed by one of the members, Mr. Commissioner, the reference to directors here is a reference to board members. Perhaps we must just make that clear.
In addition to the annual declaration of interest, when there is a change in their responsibilities within the PIC or in their personal circumstances, directors are required to disclose in writing any relevant, new, or additional information about those interests as soon as possible. Where an actual or perceived conflict of interest cannot be avoided, directors must take the appropriate steps to manage the conflict. The company secretary is responsible for receiving and ensuring the confidentiality of all disclosures and for ensuring that any actual or perceived conflict of interest is avoided or effectively managed.
If I may again interrupt you, Mr. Commissioner, to sum this up, Mrs. Lowe, would it be correct to say annually the chairperson and all members sign a declaration of interest?
That's correct.
And then at every board meeting, they sign a declaration of interest again.
That's correct.
And when they sit in other committees with officials of the PIC, they again sign declarations of interest.
That's correct.
Thank you.
Then meeting management. The board and board committee meeting dates are aligned as far as possible to the provisions of the board charter and the terms of reference of each committee and to the annual work plan of the board and board committees. Meetings in addition to those scheduled may be held with approval of the chairman of the board or board committee Exco or Exco committee, or at the request of the chairman of the board for board and board committees, or the chairman of the Exco for Exco subcommittees. All members must receive fair and reasonable notice of such a meeting, outlining the matters to be discussed, and must acknowledge receipt of the notice of the meeting. The company secretary checks and confirms quorum with the chairman before the meeting starts. Upon commencement of the meeting, an attendance register is circulated and signed by all members, and the declaration of interest register is circulated and signed by all the attendees. Where a conflict of interest situation is identified, the relevant director or attendee is required to declare the conflict or perceived conflict of interest at the beginning of the meeting, and where possible before the meeting. The director or attendee must recuse him or herself from the discussions or decisions in respect of the existing conflict or perceived conflict of interest. They are not allowed to vote on the decisions in respect of the existing conflict or perceived conflict of interest, and the relevant director may be restricted from accessing documentation in respect of the existing conflict or perceived conflict of interest, pending the board's resolution or decision regarding the conflict or perceived conflict of interest. Since December 2017, all discussions at board and board committee meetings are recorded, including the in-camera discussions. Now we come to the investment philosophy. I'm just going to briefly focus on the investment philosophy, because the executive head's investments will elaborate more on the investment philosophy during their presentations. The PIC investment philosophy is underpinned by two broad objectives, namely generating financial returns and sustainable environmental, social governance impact. Together, these objectives are called the fresh approach. It is a smart way of making investment decisions to yield a green alpha.
It was quite a surprise to me, Mr. Commissioner, to hear about a green alpha. Perhaps the witness will explain that to the Commission.
Through you, Commissioner, green alpha is where we are, although we are striving for investment returns for our clients, we also need to take into account the sustainability and the environmental and governance, which then bring in the green part of it, where we say we look at the environment, and even though we can perhaps make a great financial return, if the environment are not conducive for or good for the South African citizen, then we will rather look at ways to improve the environment, and then perhaps release the alpha, make the alpha more greener, so that we can say alpha is green.
Again, Mr. Commissioner, if I can interrupt, this is all in alignment with King 4, that you must take into account social impact, environment, etc.
And this is in a laywoman's language, that I've tried to explain that. Then we've got the schematic diagram of the investment philosophy. The PIC's investment philosophy is anchored on the following key principles: the financial return, to generate excess returns for the clients above their stipulated benchmarks, and to invest directly into the economy through developmental and impact investments. This is premised on the following. Given the size of PIC's assets under management, South Africa's GDP growth is critical for the growth of the institution's assets. We can't grow our assets without having an impact on the South African GDP, and the South African GDP cannot grow if our assets aren't growing. investing not only on the Johannesburg Stock Exchange, but directly in the economy across various sectors to stimulate growth while generating returns and contributing to the broader social economic transformation of the country is very important. The second key anchor is the environmental, social and governance. This anchor is critical in ensuring the long-term sustainability of the returns generated.
I'm sorry, where are you reading from now?
So this is I'm trying to explain the diagram.
It is not in writing in the statement before you, Mr. Commissioner.
We believe in investing in companies that take measures to protect the environment, are socially responsible and have good corporate governance. And then some of the other pillars are risk management, diversification, the time horizon, market efficiency, valuation and analysis, and cost. All transactions are subject to various board-approved policies as well as ESG frameworks and policies, all of which are based on international best practice and are aligned with applicable legislation and regulations. The Delegation of Authority framework delegates responsibilities for different transactions to a variety of role players across the PIC and also outlines the powers of the board committees, and those of the executives. The PIC has implemented a rigorous due diligence process which any transaction worth pursuing is subjected to. This process includes, but is not limited to, independent risk assessment, financial due diligence, technical assessment, legal due diligence, environmental, social and governance due diligence, as well as commercial due diligence. Where there is a lack of internal capacity, these are outsourced to external service providers and experts. The various PIC support functions assist with post-investment monitoring, value add, and reporting throughout the investment tenure until exit.
If I again may interrupt, Mr. Commissioner, if you can just make a note. The next witness will deal in detail with these aspects.
The current PIC approval committees that preside over the investment considerations comprises the portfolio management committees, the fund investment panels, the investment committee, and then the board. The board committees and Exco committees all operate in accordance with approved terms of reference, the delegation of authority, and approved policies. In assets under management, the PIC is one of the largest asset managers on the African continent in terms of assets under management. The total assets under management as at 31st March 2018 was 2.08 trillion rand, having grown by 155 billion rand compared to the previous year. This reflects the combined and separate mandates of each of PIC's clients.
Chair, perhaps I can just intervene again. It's mind-boggling figures, and for people not in the financial world, how many billions is a trillion?
That I don't know.
The assistance from the back, it's 1,000 billion is a trillion. I can't understand it, but for the record, that is the answer.
PIC clients. Each of PIC's clients has specific investment objectives expressed in the investment mandate given to the PIC to execute. These client investment mandates are based on actuarial asset and liability studies and approved by the Financial Sector Conduct Authority. Below is the list of the PIC's clients.
Can I just interrupt again? Mrs. Lowe, can you please just explain to the Commission why these people are your clients and how did it come about that they became your clients?
Some of these clients, as I mentioned previously, are in terms of their legislation, they are investing with the PIC. But the PIC has also in 1984, when we took over the public debt commissioners, inherited some of the clients, which are smaller clients, and some of them has like 10 million rand invested with the PIC.
Does the PIC go out to look for clients?
PIC does go out to look for clients. In terms of our act, the minister can give us that authority, but at this stage we did not go out and look for clients. We don't have any client that did not come or that does not invest with PIC in terms of legislation.
With these clients, how often do you negotiate the fees with these clients, and are the fees very different from one client to another?
Yes, sir. The fees are different in terms of the different portfolios. But for our three major clients, which is the Government Employees Pension Fund, the Compensation Commissioner Fund, and the Unemployment Insurance Fund, the fees are the same for the different portfolios. We are negotiating the funds on an annual basis, and some of them, the mandate will stipulate that the mandate is in place for a certain period, whereafter we will then renegotiate. And again, the Executive Head Impact Investments, which will present this afternoon, will talk more on the fees. Our clients are the Associated Institutions Pension Fund. This is now not in terms of the size of, it is just the list of the clients. In alphabetical order. The Bruins Research Fund, Compensation Commissioners Fund, the National Skills Fund.
We've got them in front of us, and you don't have to go through each and every one of them.
Thank you, Mr. Commissioner. In the asset classes, the diagram below depicts the asset class composition of the portfolio as at 31st of March 2018. Each asset class is indicated in the table below and is aligned with the PIC investment philosophy. The percentages there is as a percentage of the assets under management. The asset classes are divided between listed investments and unlisted investments. In listed investments, we manage 39.94% of the assets under management internally. The listed fixed income that is managed internally is 33.20% of assets under management. Then the cash and money markets is 5.38%, and then we've also got externally managed funds, which is 9.32% of the assets under management. The global listed equities is 4.38%, global listed bonds 0.99%, and Africa listed investments is 0.86% of the assets under management.
Just to assist the Commission, when you talk about global listed bonds, who will be a client there?
The global listed bonds will, for instance, be Eskom, Transnet, the IDC, Sanral is also.
Thank you.
The unlisted investments is private equity 1.02%, impact investing 2.35%, the properties is 2.26%, and Africa unlisted investments is 0.3% of the assets under management. Combined assurance and risk management oversight. Effective management of risk is a critical lever and enabler in delivery on the PIC strategy and is integral to good corporate governance. The PIC recognizes that it has a responsibility to its shareholder, clients, and other stakeholders to manage risk effectively, with the aim of protecting the assets under management against undue losses and minimizing uncertainty in achieving its strategic objectives. Risk management is a process that involves the identification, assessment, prioritization, and response to risks affecting the organization. The management of identified risks ensure that PIC minimizes the probability and impact of negative events and maximizes the potential for credible investment opportunities. The PIC has adopted an enterprise-wide approach to managing risk, which is embodied in the corporation's enterprise risk management framework. This framework codifies the PIC's approach to identifying, measuring, monitoring, reporting, and managing risks throughout the corporation. In its design, the Enterprise Risk Management Framework adopts risk management and governance principles from the ISO 31000 Risk Management Standard and the King Report.
Can you just explain to the Commission what is the meaning of ISO 31000?
It is a standard that is issued in terms of risk management, and PIC adopted that specific standard. It is like the King 4 that gives certain guidelines. The ISO is also a guideline. The PIC is acutely aware that some risks can never be completely eliminated and constantly evaluates its operating environment to proactively identify and respond to risks. Through this continuous process, the PIC identifies risk inherent to the corporation's core activities and adopts controls and business practices to manage these risks with acceptable levels. Evaluation and assessment of risk is conducted through bottom-up and top-down approaches, where risk is reported at management and board level. The treatment of risk is dependent on the severity level of the impact of the inherent risk to the corporation. The risk treatment responses, which follows from the Enterprise Risk Management Framework for the corporation to consider, are manage risk, is to accept the risk, reduce the risk, to transfer or share the risk, and to avoid or reject the risk. As a good corporate citizen, the PIC also subscribes to the principles of the King Report as it relates to the robustness of both risk management and good governance. The PIC has adopted the principles of combined assurance contained within the King Report. Under combined assurance, PIC follows the 3 lines of defense methodology, which is shown on the next page. The PIC combined assurance partners comprise of risk management, compliance, and internal audit departments. Over and above independent internal assurance, the PIC is also overseen by external assurance providers, including the external auditors, as well as other regulatory bodies. Then, Mr. Commissioner, human resources and remuneration. The core of PIC's remuneration philosophy is the need to reinforce and reward excellent performance that supports the values, vision, and mission, as well as strategic objectives of the PIC. The PIC uses accredited service providers to conduct salary benchmarking so that it remains relevant in the labor market and to attract and retain top talent in the asset management industry. PIC's remuneration policy guides and provides the framework for reward practices that enhance the employee value proposition. The PIC subscribes to the total cost to company remuneration structure, which consists of total guaranteed pay, inclusive of employee benefits that are subsidized, such as medical aid and funeral cover, and variable pay, which includes short-term incentives and long-term incentives. PIC uses the balanced scorecard's performance management tool to determine individual and corporate performance. PIC's total personnel cost and the achievement of the corporate balance scorecard determine the distributable incentive pool, and all governance processes have to be observed before payout. Once the board sets the overall entity incentive pool, the PIC goes through a structured process to ensure that individual allocations are in line with the formula contained in the remuneration policy. This process entails the following steps. The board determines the incentive pool. Managers assess individual performance against individual objectives and in line with PIC's corporate balance scorecard and values. Consistency checks are conducted at entity, business unit, or functional level through a moderation committee. The Human Resources and Remuneration Committee reviews and recommends the incentive pool for corporate and senior management to the board based on achievement of performance objectives. The total incentive pool is then approved by the board based on PIC's financial performance. Incentives for Exco members are approved by the shareholder, and the Internal Audit Department audits all the calculations before payment of incentives. Thank you, Mr. Commissioner.
One question, the bonus pool, or are there two types, one for the executives and one for the normal employees, or is just one bonus pool?
It is just one bonus pool, sir.
And the first part will be determined by the board for the executive, and the second part?
Now, the first part, the entire bonus pool are determined by the board, and then the board approves the payout for the employees. But the executives must first go to the shareholder. The shareholder approves the rating and the payments to the executive directors. But our executive head, Human Resources, will also elaborate more on that, sir.
Thank you.
Mr. Commissioner, this is the evidence of the acting secretary. It sets the framework, and we will proceed this afternoon with more detailed evidence on other aspects covered already in this statement by the witness. I've arranged for the next witness to be available at 2. Will it be convenient for the Commission then to adjourn now?
Yeah, I just have one question before we adjourn. Paragraph, where is it? 1.5 of our terms of reference says we've got to investigate whether the approved minutes of the PIC board regarding discussions of any alleged impropriety referred to in paragraph 1.1 are an accurate reflection of the discussions and the board's resolution regarding the matters, and whether the minutes were altered to unduly protect persons implicated, and if so, to make a finding on the persons responsible for the alterations. In the file that I received at the beginning of the Commission's life, there's a copy of minutes of the Public Investment Corporation special in-camera board meeting held on Friday, 29 September 2017 at 9. There is another copy. This is this copy that I have in front of me has lines that have been crossed, and there are 2 other copies without any lines crossed. Can you explain what has happened there?
Thank you.
Are you able to explain?
Mr. Commissioner, thank you for mentioning that. This witness can, in detail, assist the Commission on the recording of proceedings of the board, the typing of minutes, correction. May I, with your permission, then later on that aspect? It's not in a formal statement, but I've consulted with her, and she can assist the Commission.
Yes. Do you prefer to do that this afternoon?
Mr. Commissioner, I can do it now, or otherwise after 2, I'm in your hands.
I think we can do it now.
Thank you, Commissioner. Mrs. Lowe, can you just explain to the Commission who takes minutes at board meetings?
It is myself and the company secretary.
And you have already testified that the proceedings are recorded.
That's correct.
Now, how do you prepare the minutes of a meeting? Can you just explain to the Commission?
Specifically a board committee, we are attending the board committee, myself and the company secretary. Then from December 2017, we started to record the in-camera meetings as well. Prior to that, the in-camera meetings were not recorded. And then during the meeting, I will take notes, and then after the meeting, compile the minutes. In-camera meetings, like the one on the 29th of September, the company secretary was attending that in-camera meeting. The meeting was not recorded. She took notes, and she then gave her notes to myself and to the assistant company secretary to type the minutes, to start preparing the minutes from her notes. After that, we gave the draft to her. She then changes the minutes in line with the discussions which she made and could remember from the board meeting on that day. The changes she gave back to us so that we can change it. And depending on who of us work on that specific minute, it differs. Some of us would do the track changes, others will just change it.
Okay, if I can start with a normal board meeting. You will be present at the board meeting.
Yes,
And you will type the minutes from the recording and the notes of that meeting. Is that correct?
that's correct.
The final product typed will go back to the board for approval. Is that
Yes.
the normal process?
Yeah.
Right. With regard to in-camera meetings, I understand then the officials of the PIC are then asked to leave the meeting,
That's correct.
but only the board secretary will then remain. Is that correct?
The company secretary.
Sorry, the company secretary
That's
will remain. She will then take notes of the meeting,
That's correct.
and that notes will then be given to you to prepare minutes.
That's correct.
The draft minutes prepared by you will then go back to the company secretary for
Yes.
corrections, and those corrections will come back to you or your colleague for finalization, and that again will then go back to the board for
To
approval.
the board for approval.
I hope that assists you, Mr. Commissioner.
I suppose it does. But looking through the minutes or the set of minutes where lines have been drawn through lines, what does one do with that? Do I say, this is what was said in the meeting and later deleted? So that the minute, the final minute does not reflect where a line has been drawn through.
Through you, Commissioner, the final set of minutes is the minutes which is signed and approved by the board. All the previous sets of minutes are just draft minutes, and they've got no legal standing until they are approved and signed by the chairman of the board.
And will the final approved minutes have manual corrections on it, or will it be the complete corrected minutes?
It will be the complete corrected minutes, but if a director, after the minute has been signed, if there is then an attestation or a dispute about the correctness of the minute, it may be corrected legally with the hand, manually, but then the chairman must sign by it. The directors, of course, has the authority to change the minutes before approval. They can provide the company secretary with input which we will then affect if we are in agreement with that, and then at the board it will be approved.
Just for clarity, you see the set of minutes where there have been lines drawn through lines in the minute consist of about 9.5 pages. And the minute that I see was signed by the chairman on 1 December 2017 has about 7.5 pages. Does that tell me that certain matters or certain things that were said are contained in the almost 10-page minute, which were then left out and left the minutes with 7.5 pages?
Yes, Mr. Commissioner, you are correct to say that, but it is still the board's prerogative to say let's rather concise certain discussions in a smaller summary and only include a small summary of what was said and not basically verbally.
So in order for one to have a clear view is that you read both and you see whether there are things left out in the final minute or not. Am I correct there?
You are correct, sir, but the draft minutes are normally only for the PIC. It's not for other people. It's not public.
I think, Jay, if I can assist, do you know of any instance where board minutes were changed?
Tombi, yeah, so kung ungcheckele ilo i-camera leti operator wabudlamini. Ngiphambi kwayo manje. Ngiyathola odd. Oh, okay, sharp. All right, okay. So good.
Okay, good. We're all good. How's it?
So I'm good, and how is you?
You know, can't complain.
It's always good to see you on a smile.
Oh, thank you. Well, my makeup bag. My vanity bag.
Word balance quick. What do I do? Please get up. Thank you.
Hello? Hey. Hey.
The face is gone.
Yeah, sure, thanks.
Who cried?
Channel 1.
Yeah.
Ibu channel 1.
Okay.
Ibu line or Mike?
Mike.
Oh. Yeah, Ibu Mike. Ibu channel 1.
Do you have a guest?
Sisi camera. Sabi camera le manje. See right now.
Numbu, let's work together.
Kuluma Mike.